The right to a speedy trial. That's one of the things we're going to talk about today in this short live stream we're going to do, talking about the Sixth Amendment of the U.S. Constitution and how it reflects on Donald Trump's trial in the District of Columbia and the demands made by the special counsel, Jack Smith, that were echoed by the judge, by the Obama-appointed judge. The Sixth Amendment is most people, it, but most people don't realize what it is. The Sixth Amendment says in all criminal prosecutions, the accused, not the government, the accused, that would be Donald Trump in this case, shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law and to be informed of the nature and cause of the accusation. Okay, so I'm going to just stop right there because that's the crux of this. The accused, Donald Trump, has a right to say, hey, I need this time picked up on this. The government, this is an individual right. It is not a government right. It is, in fact, a government right is an oxymoron because the Bill of Rights were designed to protect individuals and states from an overbearing, overpowerful federal government. So there is no governmental rights per se. There are protections against government abuses. So this isn't a protection against the government abuse, and the abuse is exactly what the Biden administration has done to January 6th defendants. Throw them in jail, throw away the key, delay trials, and basically hide exculpatory evidence. That is what's happened to January 6th defendants who made the mistake of wandering around the Capitol and taking photos in the Capitol dome. But that's not what this is about. This is about whether or not there is a Sixth Amendment at all, because if it's not an individual right, then it is not a right. And the Biden prosecution team has attempted to turn this into a government right. Here's what they actually argued. First of all, understand the Department of Justice, the Biden Justice Department, has provided the Trump team with 12.8 million pages of documents in discovery. 12.8 million pages of documents. The Trump team says it's going to take a long time for us to go through that, to call out exculpatory information, to see if your documents are, if we're disputing those documents, to be able to get witnesses who can say, wait a second, what you're saying here isn't true. And to find contradictions in the documents to show that the prosecution in its own discovery filing showed that they actually had no case whatsoever. 12.8 million documents, much of it testimony, some of it legal, certainly something that they're going to have people actually read it, not just attorneys, but people who were there. Does that really meet with what your memory says occurred? So they can effectively challenge witnesses, so they can offer witnesses to the contrary. And Donald Trump did not find out what charges were being levied against him until August 1 of this year, 2023. And so the judge, Tanya Chutkan, appointed by Obama, and somebody who has been rabidly aggressive in sentencing against J6 defendants, she said, well, actually, let's go with what she set the trial date at, March 5th, March 6th, March 4th, the day before Super Tuesday, the Super Tuesday primary, in a direct attempt to interfere with the primary election. Yeah, that's what Tanya Chutkan did. She said, hey, Donald Trump, you're going to be battling for your life, for your freedom for the rest of your life. And, you're not going to really campaign aggressively in small little states like, Alabama, Alaska, Arkansas, California, Colorado, Maine, Massachusetts, Minnesota, North Carolina, Oklahoma, Tennessee, Texas, Utah, Vermont, and Virginia. Now, you're not going to be able to do that because you're going to be tied up going and trying to defend yourself and reviewing a bunch of documents and trying to make certain that you have adequate defense on the day before those primaries. It was deliberate. It was a political move, and it's typical of the Biden administration and the Obama appointees on the court. But here's what DOJ did. DOJ argued that since 60% of the pages were things the defense should already have had access to, there was no reason to delay the trial due to volume of information to scrutinize. In other words, you don't know what we're going to charge you with, so consequently, you don't have it. You should be able to guess what we're going to charge you with, and be able to review the documents in light of the specific charges, the specific allegations, and you should be able to do that in a short period of time because, after all, you might have known, you should be familiar with some of the information. Well, I'm sorry, but that's not the way it works. See, the way our actual system of justice is supposed to work is it's not justice by convenience to the prosecution. It's justice to give the defendant, Donald Trump, every right and every privilege to be able to deny and persuade that the assertions by the prosecution are false. And in fact, they don't have to prove they're false. All they have to do is prove doubt, reasonable doubt that they are false. But that takes time. It takes a lot of organization. It takes a huge amount of effort. It takes a lot of people to look at all this. And so here's what the prosecution actually said. Biden's prosecutors argued that Trump's D.C. trial should happen as soon as possible. That's a quote, citing President Trump's nearly daily comments about the case, arguing, quote unquote, this potentially prejudices the jury pool, and so under the Speedy Trial Act, Your Honor, we need to find a time for a trial as soon as the defense can reasonably be ready, end quote. The judge dutifully responded with the pre-Super Tuesday trial date, saying, quote unquote, the public has a right to a prompt and efficient resolution of this matter. No, wrong. The public doesn't have a right in this circumstance. The president, Donald Trump, has rights, individual rights. He is innocent until proven guilty, just like every other person facing criminal prosecution, innocent until proven guilty. Joe Biden is innocent until proven guilty of the charges that are against him. Hunter Biden, innocent until proven guilty of the charges against him. That is the system. That is how it works. That is what the justices are supposed to stand for and say, no, we're not going to allow somebody to be railroaded. And yet, Biden's prosecutors, we need to have this happen now. Yeah, shoot, it's no big deal. It's only 12.8 million pages. And by the way, it's no big deal to try to find people to go and take big sections of it and read it and say, is that how you recall it going? And be able to actually go through line by line and with people who are in the room, people who had real knowledge of what happened, and say, looks like this might be valuable. What's more, since Donald Trump is standing trial in D.C. and in Atlanta, he's got 18 co-defendants, all on basically the same charge. You know what? Those 18 co-defendants are probably witnesses for Donald Trump's defense. Certainly possible. The most likely people to be witnesses for his defense on the charges in D.C., the federal charges, are the people who've been charged in Atlanta under state law. Those people can't testify because they're facing their own criminal charges. So they can't testify. They're not available to testify. So the most compelling witnesses for Donald Trump's defense are ineligible to testify because of the trial of the charges in Atlanta, in Fulton County, creating an absolute denial of basic Sixth Amendment rights for President Trump. No doubt, this is a denial of the Sixth Amendment rights, because I'm just going to go to the end of this. which district shall, I mean, okay, to be confronted, this is the second half of the Sixth Amendment, to be informed of the nature and cause of the accusation. That occurred on August 1, 2023, when Donald Trump was indicted. That is the first public acknowledgement of what the actual charges were. So counter to what the federal judge said, when this has been going, where she said, this has been going on since January 6th. So we're over 3 years into this. You've got to have, or we're around 3 years into this. And by the time this trial date will be over 3 years. That's plenty of time to get your ducks in a row. Except for Donald Trump didn't have 3 years. The prosecution had 3 years. Donald Trump has from August 1 to the trial date, March 6th. Okay, that's what Donald Trump has. So the whole premise here is that the government gets all the advantages. They get home court advantage, and that they are going to try the case in D.C. They're going to have a jury, not of Donald Trump's peers or even anybody who supports him. They're going to have a jury of the very swamp that Donald Trump vowed to take on, and he's being prosecuted for taking it on. That's who. And so, you look at it and you say, every aspect of this trial reeks. Every aspect of this trial reeks. But for the Justice Department to sit there and try to pretend that you've got plenty of time. This is the same Justice Department, the Biden Justice Department, that took 4 years to unwind the plea deal with Hunter Biden on his tax avoidance and his gun charge, and to create a plea bargain agreement that fell apart in court. They had to wait until the more serious tax charges had gone by the wayside, so they weren't charging Hunter Biden with tax crimes for things that happened during when Joe Biden was vice president. So they had to wait. So they let those charges die because they didn't file them on time. And there's a 7-year time limit for filing those charges. They didn't do it. So no push for a speedy trial in the Hunter Biden case, even when had a compressed timeline in terms of the charges become null and void because of the 7-year time frame for a charge to be brought on a tax crime. So you look at this and you just say, what are they doing? Well, the last piece of this, and I did not write this in the Daily Torch Report I wrote on this today, was Chutkin, the federal judge, saying, well, and besides, Donald Trump has, I'm paraphrasing now, besides, Donald Trump has plenty of money, so he can afford to pay a lot of people to look at all these documents. So it really isn't it's not an inconvenience. He just needs to spend more money. Since when is that a criteria? Oh, so now you're saying that we can railroad somebody because they've got enough money that they can spend every dime they have. They can, get enough attorneys, enough people to read 12 million pages of documents in a relatively short period of time, analyze them, catalog them, identify witnesses who would be pertinent, try to get those witnesses to, vet those witnesses, basically figure out what their defense is based on the uniqueness of these charges, where they are, shall we say, made up out of whole cloth. And it's under the fraud statute, which completely does not apply. But nonetheless, we have we're going to railroad Donald Trump. And just make a mockery of the entire justice system, because after all, it's really inconvenient that Donald Trump can talk about these charges. He might be hurting the jury pool. The federal prosecutor has been leaking stuff about Donald Trump for the entire time of his existence. Before that, we had the J6 committee putting stuff out into the public domain, which was in D.C. people were paying attention to. People weren't paying attention to it elsewhere in the country, but they're paying attention to it in D.C., where the jury pool is. They never heard, the J6 committee in the House never heard a witness that was on Donald Trump's side. They only heard witnesses that were attempting to undermine President Trump and try to make up a case that he was guilty of something. So they've never heard Donald Trump's side of the story. So what the prosecutions actually say, the Biden prosecution saying, gee, if we have this case stretch out past the presidential election, for instance, Donald Trump's going to be able to tell his side of the story. And people will get to decide based on hearing both sides of the story, not just one side. Oh my gosh, we can't have that in our star chamber judicial system here in Washington, D.C. The Biden prosecutors can't have Donald Trump having a voice, being able to tell his side of the story. Nope, we have to just railroad it through, cram it through as fast as possible, try to disrupt the primary elections, and create an environment that where the entirety of the judicial system has a mockery made of it, and the most important trial our nation is going to have in its history. Because this trial is about whether or not Joe Biden, a president, can use the power of the presidency to prosecute his opponent, the former president. That doesn't happen in America. It happens around the world. It doesn't happen in America. But it's happening now. And the Justice Department and the Biden Justice Department says, well, we don't really want Donald Trump to be able to make his case to the public about why these charges are bogus. So we need to push them through as fast as possible. Because after all, the objective is to stop Donald Trump from becoming president, and rule of law be damned. I don't know about you, but I'm sick of it. I'm just sick of it. And I know that there's reported that once the trial judge decides that the trial date is a certain date, that it's not really appealable. But the fact of the matter is, this is a complete and total miscarriage of justice, and it's why I started with the Sixth Amendment. If something there is no such thing as a federal government right. Federal government does not have rights. The federal government is set up and in such a way that the rights are protections of individuals or states against the abuse of power by that federal government. And yet the Biden prosecutor argued that it was the government right to have a speedy trial, and it was a government right to make certain that Donald Trump that they shut him up, and that he couldn't tell his side of the story into a jury pool that is already set up to convict him based upon the people who are going to be in it, who live in Washington, D.C. And the fact is, you will not find anyone in D.C. who is not already set up and ready to go and to convict Trump. That's the grand jury is a rubber stamp. The prosecutor's using that rubber stamp, and Biden is running roughshod over the judicial system, while at the same time facing actual, real, credible criminal charges against his son and potentially against the President Biden. That if they continue to proceed with this, the Biden family itself will pray that Donald Trump has a merciful heart, because they will suffer under the rules they're setting up. And if they're forced to play by those same rules, we are going to see our nation fall into a nation where you better not lose an election, because if you do, you're going to end up prosecuted and in jail. It's not America. It's not who we're supposed to be. Joe Biden is breaking the system. And it's really going to be hard to convince anybody that when Donald Trump is elected president, that first acts in office shouldn't be going after the people who have broken that system in their zeal to get him thrown in jail and denied his freedom. I'm going to look at the chat here. Let's see here. Let's see. But yet want to continue Trump's Jody Price. But yet want to continue Trump's. I don't even know what you're doing there, but Jody, If you can't understand that violating the rights of all of us so you can go after your political opponent is a problem, I feel sorry for you. Let's just go down here. Let's see here. The Democrats are railroading President Trump. The Democrats have backed the KKK. The Democrats are using KKK tactics like tar and feather and to put on a rail out of town. The tactics Democrats are of the KKK. You know, Dale, the fact of the matter is they are using intimidation. They're attempting to intimidate lawyers. We know that Jack Smith attempted to intimidate one of President Trump's co-defendants and the Mar-a-Lago trial and the trial on the classified documents. We know that he supposedly flipped another, somebody who, by offering to, we'll give you an attorney if you flip to our side, and also, by the way, we also won't prosecute you. So used intense pressure to try to get somebody to say what they want in terms of allegations that Donald Trump tried to have the tapes erased, which, by the way, he didn't. He actually turned them over to them. But, it doesn't matter what happened. The question is, they need to make up something so they can come up with an obstruction charge. The fact is, we're dealing with a prosecutor in Jack Smith, a guy who so broke the rules related to prosecution in a case of a Republican Virginia governor who he got convicted of crimes that didn't actually exist, and that the Supreme Court voted 8-0 to overturn the conviction because of prosecutorial misconduct. We have somebody whose professional career is built around prosecutorial misconduct upon a win at all costs. I don't care about rights. Jack Smith is exactly the prosecutor who the Democrats need right now, but who all Americans should fear. Because a prosecutor who doesn't care about justice, doesn't care about innocence and the presumption of innocence, a prosecutor who will do anything to win and pays no attention to the Constitution that he's destroying, that's a prosecutor who is one of the most dangerous people on earth. And unfortunately, based on how quiet much of the federal prosecutorial community has been, it makes me wonder if he's an anomaly or if he's the norm. And God help us if he's the norm. Let's see. Nancy Pelosi's daughter had a special meeting for filming a premeditated plot conspired by her mother. Yeah, she was filming. She did. She filmed. I think she was doing some stuff on January 6th, and she was busy creating a film. I know that Pelosi was on the phone with her when she was supposedly fearing for her life. So it's but thank you for bringing that up. It's not something I know a lot about. I'll have to check into it. Let's see here. I'm going to just take this, Brian. When is Biden going to face justice? Brian, I'm going to answer this. I appreciate you bringing it up. The question is one that we are pushing Kevin McCarthy on every single day. We have thousands of people who've sent emails into Congress urging them to begin the process to actually start the impeachment inquiry so they can compel the turning over of documents, such as all of the emails that were sent back and forth, both sent and received, from the 5 different pseudo email addresses that Joe Biden had. He had 5 different email addresses that he had that weren't the official email addresses. And so people would FOIA the official email addresses. Oh, you don't see anything here. But he was using other email addresses. He had a guy who has 20 shell corporations and going through 13 banks. I think, using 5 different email accounts that are separate from his government account. It's a process of concealment, and it's a travesty that Kevin McCarthy did not, when he found that information out, did not immediately call the Congress back into session and say, the House back into session and say, we're opening up an official inquiry because we need to get that information. We know that Joe Biden is going to give up that information. He's not going to relinquish those emails. And yet Kevin McCarthy saying, well, if Joe gives them to it, we won't have to go forward and do this. Well, Kevin, time's up. Time's up. It's now time to actually proceed with the impeachment inquiry. You've put together the pieces. Everybody can see what's going on. And to get the rest of the puzzle pieces, you're going to have to compel the Biden administration and Joe Biden himself to comply with federal court orders. The court precedent's on your side. There's absolutely no excuse to not pursue it as aggressively as possible at this point. And the fact they've chosen to wait until September after Labor Day to even consider it, even to get back together in Washington, D.C., I think is the first sign that, one of the first signs that Kevin McCarthy really isn't all that interested in pursuing the impeachment of Joe Biden. So when is Biden going to face justice? My answer to you, Brian, and anybody who's listening, go to getliberty.org, G-E-T, Liberty, Liberty.org, getliberty.org. That's our official corporate website for Americans for Limited Government. Go to getliberty.org, click on the Impeach Biden button, and contact your 2 senators and your 1 congressman and urge them to impeach Biden. We have to put pressure on, not just on Democrats, but we have to put pressure on Republicans to do this. And they have to, in turn, put pressure on Kevin McCarthy. Because if they don't, these guys will, whistle, and they'll have hearings, and they'll clap their hands, and they'll say, oh, this is horrible, but they'll never do anything. We know the Senate isn't going to convict, more than likely, but the House needs to lay out the evidence so all can see it. And that way, it will be crystal clear. Allow Joe Biden to make his defense and to defend himself, and allow the process to work. That needs to happen now. Can't wait until we're in the Iowa caucus to do that. So, folks, Brian, I'm as frustrated as you are. I'm going to go sharp shorts. Prosecutors have no rights. They have power. The same goes for all government entities. Citizens have rights. That sums it up right there. Citizens have rights. You have individual rights. States have rights against federal government abuses, and which have changed over time. We spotted Civil War, things like that. But every one of the Bill of Rights are not a bill of governmental rights. It makes no sense for the government to have rights. The government has the power. The rights are the individual protections against that power. And the assumption of government rights is an assumption of that there's no individual rights, and that the government itself is preeminent, and all power, all rights come from the government. The Bill of Rights is with protections against the government. And, oh, by the way, the presumption of innocence puts all the burden on the government to make a case. And when the government sits there and says, well, it's not fair, he's talking about it, that's his problem. If he says, he can say, somebody can publicly say stuff that cause people to vote against him. It's not his, that's not your problem, government. Make your case in a court of law. They've already they're making their case on MSNBC and CNN all the time, nonstop. And yet Donald Trump's not allowed to make his case. They're afraid of Donald Trump making his case. the world is an upside down world, and nothing's more upside down than this prosecution. And while the precedent is that you can't challenge a federal judge's ruling of when a court date will occur, I think the nature of the ruling and the statements made by the judge are prima facie evidence that this judge is ineligible to hear this case. Because if she can confuse a individual right for a governmental right, a supposed government right, she can confer rights to the government, she is ineligible to hear any case, let alone one that she's so clearly biased on. The courts will decide, we'll fight it out. But folks, ultimately we need Congress to take action, not just on impeaching Biden, but also in trying to rein in this garbage. And who knows if they'll have the courage to do that. With that, I'm going to let you go. Thank you for tuning in. We will be with you tomorrow on a different subject.